Well, let's now turn to Dr. Ayodele Akenroye, an adjunct professor at the Center for Criminology and Social Legal Studies, University of Toronto, Canada. Thank you so much for joining us on the show tonight. Well, as at last week Friday, it seems that Igboho's 5 lawyers were not able to convince the Beninois court that Sunday Igboho had no case to answer. As you may have heard from our reporter there in Cotonou, they're still waiting. Hope springs eternal, and they're hoping that at the end of the day, Igboho will be let go. But what do you make of this? Well, just like in the case of Nnamdi Kanu here in Lagos, in Cotonou there is this, lack of access by the media and other supporters of Sunday Igboho. What do you make of that? And what does that say about the justice system in these parts?
Me, it's sad that the media could not access the trial or the arraignment of Sunday Igboho in Benin Republic. If it's a public hearing and national interests are not engaged, they ought to let the media have access to them. The right to a public trial means the media being able to access it and report to the population, to the citizens of Nigeria that are seriously involved and wants to know what is going on with Sunday Igboho, and also to ensure transparency in the legal proceeding. Having said that, I think the reason why the Benin Republic is stalling is because they are working on that Article 22 of the Economic Community of West African States Convention on Extradition, which was signed in 1994, that made a provision for what is called a provisional arrest, where Sunday Igboho can be arrested while the Nigerian government is putting their house in order, maybe charge him to court, get a warrant of sentence, a warrant of arrest, or sentence him and bring those documentation to Cotonou or to the Republic of Benin to initiate or to continue the extradition of a Sunday Igboho. But circling back, it's a fundamental principle of law that if it's a public trial, if national interests are not engaged, national security interests are not engaged, which it's the judge that will determine, not the government, it's the judge that will determine whether it has to be private. Until the judge makes that determination, it's a public trial, and the media has the right to be there.
A counsel to Igboho, Babatunde Salami, warns against extraditing Igboho to Nigeria. Now, if Benin has a treaty with Nigeria and due processes, so to speak, are followed, shouldn't he be extradited to come defend himself against the allegation by the DSS here in Nigeria?
This is a very complicated and very interesting question. The issue is that before you can be extradited from Benin Republic, certain legal procedure has to be in place. The first one, which I think is missing, again, we are hearing conflicting information, is that Igboho has not been charged to court in Nigeria. He has not been charged to any court as at the moment. He needs to be charged. He has not been charged. He needs to be charged for crimes that are known to the law. If you look at Article 18 of the treaty between Nigeria and Cotonou, not only Nigeria and the Republic of Benin, between Nigeria and West African state, it talks about certain documents, important documents that must be put in place of the judges in Benin Republic before they can make a decision on extraditing Igboho. First of all, it said original or authenticated copy of the conviction.
All right. Thank you very much. Ayodele Akenroye is our guest from Canada there, talking about Igboho's case there. Criminology and social legal studies expert there.